Yes, oral agreements are valid and subsisting in their Indian law. In fact, they have the same enforceability as the written counterpart. The same was substantiated by the Honorable High Court of Delhi in its landmark judgment of Nanak Builders Investors Limited versus Vinod Kumar in 1991. Court went on to state that it is not mandatory for an agreement or a contract to be reduced in writing. In fact, it is upon the parties whether they want to sit down and reduce the terms of their agreement or contract into writing. If they choose to not do the same, oral agreement will have the same enforceability and validity that a written agreement has. Same was also reiterated by the Honorable Supreme Court in its judgment of Alka Bose versus Paramatma Devi in 2000, wherein the court even went on to say that an oral agreement for sale is valid as long as it confers or is in tandem with the essentials listed out in Section 10 of the Contract Act. However, the issue arises when it comes to proving the very existence of an oral agreement. An agreement which is reduced in writing will always have an upper hand over an oral agreement for the simple factor that it is more reliable and it is tangible in nature. It goes a long way in making adjudication process easier for the courts as well. It is therefore advisable for all the parties concerned to reduce the terms of agreement into writing. If you are, say, not comfortable in entering into a full-blown contract or agreement, you do not wish to employ the services of a lawyer, it is still advisable for you to prepare a simple one-page document that delineates the rights and duties of all the concerned parties. It will go a long way in helping you enforce your rights if something happens in the future, and it will also make the process of adjudication easier for the lawyers as well as the courts.